Okay, if you all please take your seats, we'd like to get started here. We have quite a busy morning, so we have a number of exciting panels, so we'd like to go ahead and get started if we could. Okay. My name is Mark Puste. I'm the Executive Symposium and Topic Development Editor for the Case Western Reserve Journal of International Law. I would like to welcome you to the Frederick Cox War Crimes Symposium entitled Torture and the War on Terror. We have a number of exciting panels today, and we're very happy to have you here. And without further ado, I'd like to go ahead and turn it over to Associate Dean Hiram Chodosh. Associate Dean Chodosh is the Joseph C. Hostetler, Baker and Hostetler Professor of Law here at the Case Western Reserve University School of Law. Thank you again for coming this morning.
Thank you. Good morning. On behalf of Dean Jerry Korngold and my dear colleagues here at the School of Law, as well as the Frederick K. Cox International Law Center, it's a privilege to welcome each of you here today to the Center Symposium on Torture and the War on Terror. Special welcome to those watching upstairs and on our webcast. Professor Michael Scharf, Director of the Center, will introduce the program in a moment. But first, I'd like to say a few words about the Center and its role here at the law school. Since its inception in 1991, our law school's Cox Center has attracted international attention for its innovative educational programs, prolific scholarship, and dedication to advancing global justice reform through public service. The Center offers a first-year course in global perspectives, now in its 14th year, a concentration in international legal studies, now in its 6th year, over 38 courses and an extremely successful summer institute in the Netherlands, 2 international journals, one now entering its 38th year, an immigration clinic, 5 international labs in war crimes, judicial reform, global corporate governance, financial integrity systems, and counterterrorism. 3 moot court teams, including the regional champion Jessup team last spring, the prestigious Klatsky Fellowships at Human Rights Watch, and summer internships that send up to 20 students all over the world each summer. Study abroad fellowships with students currently in Vietnam and Sierra Leone this fall, a new Fulbright case partnership in India, an LLM master's program that has educated over 300 foreign lawyers here in Cleveland, and a new LLM program currently under development in Beijing. Involving over 20 faculty here at the law school, the Cox Center sponsors several conferences and major lectures each year by opinion leaders like Harold Koh, Samantha Power, Arya Nair on issues ranging from the Middle East to international intellectual property, from cross-border regulation of controversial medical technologies to international crimes against women, from nation building to a conference later this year on bioterrorism, co-hosted by our new Institute on Global Security, Law, and Policy. This rich encounter between our community of scholars and the pressing global issues and educational challenges of our day is only possible because of the generous endowment funding by the George Gund Foundation. Named for Frederick K. Cox, a distinguished law school alumnus, longtime member of this university's Board of Trustees, and former director of the Gund Foundation, the International Law Center has become one of the university's globally renowned programs. I'd also like to thank the Wolf family and Wolf Foundation for their special support of today's symposium. Naturally, funding is necessary but hardly sufficient to produce such an exciting array of initiatives. The talent, dedication, and leadership of our wonderful students, staff, and faculty are equally essential. Nearly 10 of our own faculty here at CASE have been engaged in the planning and execution of this conference. Alice Simon and Nancy Pratt have done an incredible job organizing and promoting the conference. Our students in the Journal of International Law are equally fantastic, and we're especially fortunate to have as director of the center the one and only Professor Michael Scharf, the world's leading expert on war crimes, recently nominated for a Nobel Peace Prize, and also one of the most dynamic international educators of our day. Michael and our colleagues have succeeded in bringing us here together this morning to address one of our civilization's most troubling and pressing questions: the role, if any, of torture in combating terror, and what we should all do about it. To answer these questions, we have a record crowd of 180 registered participants today, our faculty and students, and a group of the world's leading experts. Many of our special friends who have honored us previously with their special insights: Richard Goldstone, Sharif Bassiouni, Layla Sadat, Bill Shabbos, just to name a few. So please join me in giving a warm hand of congratulations to Michael Scharf as he introduces the conference. Michael, thank you very much.
Well, let me begin by thanking Hiram for the very kind remarks and the hyperbolic statements that I pay him to say about me. No. Seriously, Hiram Chodosh was the director of the International Law Center before I arrived and before he was elevated to be the associate dean, and he built this center to be what it is today, and we are lucky to be able to build upon his accomplishments. Well, welcome, everybody, to this conference. We have a record number of attendees for one of our Cox Center conferences today. We have over 185 people registered, and they are located in this room and also upstairs in an overflow room. So we'll be getting Q&A questions, and we'll also be speaking not just to you all, but to the people upstairs, and making sure that when we do Q&A, we have a microphone so that they can hear everything that's said. We're also beaming this live throughout the world on a webcast. And we know that there are already hundreds of people logging on this morning to watch these proceedings. Well, the topic of this conference, torture and the war on terror, could not possibly be more timely. Let me just read a few headlines from the news this week. New York Times: a federal judge ruled on September 29th that the Department of Defense must release dozens of withheld photos and videotapes that show abuse of prisoners at Abu Ghraib prison in Iraq, rejecting the argument that publishing the images would endanger U.S. troops. Associated Press: Human Rights Watch report documents acts of torture by U.S. troops at a base in central Iraq from 2003 through 2004 under orders of superior officers not previously reported. Chicago Tribune: the buck stops with Lindy, but what about those at the top? Reporting that Private Lindy England was convicted last week and sentenced to 3 years imprisonment for abusing Iraqi inmates, but that 230 other members of the U.S. military have been disciplined for prisoner abuse, and that President Bush has opposed calls for a full independent investigation. And then there's Interpress Service. Senator Levin has proposed a 9/11 type commission to investigate and report on causes of detainee abuse in Guantanamo Bay, Iraq, and Afghanistan. And then there's Reuters from yesterday. The U.S. Senate adopts amendments to the Department of Defense funding bill introduced by Senator John McCain, designed to correct policies that led to abuse of prisoners in U.S. custody in Guantanamo Bay, Iraq, and Afghanistan. Vote is 90-8. Bill goes to conference committee next week. And then there is today's headline from USA Today: quote, controversial interrogation techniques enable U.S. and allies to foil 10 terrorist photos, President says. Well, this conference is serving as the annual meeting of the American National Section of the International Association of Penal Law. This is particularly appropriate because our closing speaker, Sharif Bassiouni, where are you? There? In 1978, when he was president of the International Association of Penal Law, he drafted a document that later became the Torture Convention. And it was submitted on behalf of the organization, which has played a significant role in this area. And we're very glad to have Sharif here to close our proceedings and to lend us this historic link to the past. We're also the annual meeting, as the annual meeting of the International Association of Penal Law, we begin the proceedings by recognizing this year's AIDP Article and Book of the Year award winners. And there was supposed to be a plaque right here. Nancy, do you have those? All right. I'm going to do that in a minute while she gets the plaque. Before I do, I should also mention that the conference is also a centennial regional meeting of the American Society of International Law, and we are extremely fortunate to have as our keynote speaker for the conference the president-elect of this very highly respected, scholarly and academic and practitioner-oriented organization with over 3,000 members from the United States and abroad. I want to again echo Hiram's remarks, thanking the Wolf Family Foundation for its financial contributions to this conference. I want to thank the members of the program committee, my colleagues, Amos Giora, who will be here as soon as his flight lands from Israel, Bob Strassfeld, Chip Carter, and Jesse Hill, who helped me assemble a stellar conference lineup, and the Case Journal of International Law, which will be publishing the articles generated from this conference, and there are information about how you can order copies of those. And finally, the managers of the Cox Center, Alice Simon and Nancy Pratt, who took care of all the conference arrangements. I'm still sort of stalling for Nancy to come in with the giant plaques. There she is. Okay. All right. Thank you.
Thank you.
This is Nancy, and she does deserve applause for so many things she does. This year's Article of the Year goes to Professor Diane Aman of the University of California Davis School of Law for her amazing article that is appropriate to this year's conference entitled Abu Ghraib, which appeared in the University of Pennsylvania Law Review in June 2005. Diane? This year's Book of the Year award goes to Professor Ellen Podger of Georgia State School of Law and Roger Clark of Rutgers School of Law, who are co-authors of International Criminal Law, Cases and Materials, a wonderful case book published by Lexis Publishing. Would you two please come down and... And these folks came all the way here to be here for this conference from, well, Roger's from New Zealand, but he came from New York. And Ellen came from Georgia, and Diane came from the West Coast. So thank you all for making the trip to be here. Last week, Abby Mann, who wrote the Academy Award-winning movie Judgment at Nuremberg, spoke at a conference I participated at in Chautauqua, commemorating the 60th anniversary of Nuremberg. How many of you are familiar with that movie? It's a famous one. It got 11 Academy Awards. I see a number of you. The movie was based on the real-life Control Council Law No. 10 judges' trial at Nuremberg, in which the judges and prosecutors of the Third Reich were tried for being accomplices to crimes against humanity for permitting the German judicial system to be perverted into a weapon instead of an instrument of justice. When I read the script, which Abby Mann was kind enough to give me, and you can always get these on Amazon if you're interested, I was struck by its relevance to the topic of our upcoming conference, which we now have today. I want to take a minute to read a passage from the judgment delivered in the movie by Spencer Tracy, who played the presiding judge. And I'm going to do my best Spencer Tracy imitation, having seen this a number of times. I think I have his cadence down, if not his grovelly voice. And think about, while I read this, the relevance of today's conference. The defendant's record and his fate illuminate the most shattering truth that has emerged from this trial. If he and all the defendants had been degraded perverts, if all of the leaders of the Third Reich had been sadistic monsters, then these events would have had no more moral significance than an earthquake or any other natural catastrophe. But this trial has shown that under a national crisis, ordinary, even able and extraordinary men can delude themselves into the commission of crimes so vast and heinous that they beggar the imagination. How easily it can happen. There are those in our own country, too, that speak today of the protection of country, of survival. A decision must be made in the life of every nation at the very moment when the grasp of the enemy is at its throat. Then it seems that the only way to survive is to use the means of the enemy, to rest survival on what is expedient, to look the other way. Only the answer is, survival as what? A country isn't a rock. It's not an extension of oneself. It's what it stands for. It's what it stands for when standing for something is most difficult. Before the people of the world, here in our decision, this is what we stand for: justice, truth, and the value of a single human being. Well, Abbie Mann's apocryphal words spoken by Spencer Tracy raise the questions that will be addressed at this conference. How do we combat terrorist threats to our society without destroying the very values of our society? How do we protect our constitutional democracy without contravening the fundamental constitutional and democratic principles? And how do we ensure the survival of our country and at the same time make sure that we can live with what survives? In the margins of the panels and during the debate, we will be discussing the draft Cleveland Principles on detention, treatment, and trial of persons in connection with the global war on terrorism, a copy of which was handed to each of you when you came in. This will help us focus our debate and will make this conference more than just an enlightening academic exercise, for these principles may in fact be adopted and widely circulated through the United Nations. To kick things off today, we have an amazing keynote speaker, Professor Jose Alvarez of Columbia Law School. He began his career as an attorney advisor at the State Department. He rose to prominence as one of the most respected international law scholars of our generation. And he has recently been elected president of the American Society of International Law, the most prestigious learned society in the field. He tells me that in writing his remarks for today, he checked with his lawyer to make sure that he wouldn't run afoul of any libel, which tells us that we're going to be in for a real treat for some provocative and exciting remarks. It is my greatest pleasure to welcome Jose Alvarez.
Thank you, Michael. As Michael knows, I was reluctant to come to this conference. Lawyers of all people whose lives are devoted to controlling the arbitrary exercise of power should not be, in my view, discussing the torture and cruel and inhuman treatment of individuals as if it was just another policy choice that's equally acceptable. But sadly, the actions of governments in the war on terror make conferences like this necessary, and we're forced to revisit that enemy of all mankind, the torturer. Now, the Bush administration's astonishing paper trail of apparent complicity in torture has now been authoritatively compiled in Greenberg and Dratel's The Torture Papers. And thanks to this, thanks very much. Thanks to this 1,200-page tome of memoranda and reports, we have now discovered that the torture is no longer merely that alien that's subject to the Alien Tort Claims Act, that outsider on some third world totalitarian shore. The torturer is us, distinguished, highly credentialed, high government officials, current and former professors of law at famous law schools, even one who has since become a federal judge. When such folks are complicit in torture in rule of law states such as our own, their actions take a different shape than in Filartica. That is, when a chief of police takes it upon himself to torture and kill without warrant in Paraguayan law. When our high-level torturers act, they do not do so by ignoring the law, but by systematic and reasoned misapplications of it. This is not torture outside the law, but under it. Now, graduates of Harvard and Yale law schools, former clerks of the U.S. Supreme Court, do not themselves strap people down on waterboards, attach electric wires to their appendages, handcuff them in stressed positions that cause them to suffocate, withhold vital medical treatment, or threaten naked detainees with attack dogs. They write legal memos that permit other people to do these things. In our legalistic culture, our low-level operatives demand such memos, because they have learned that they risk being left high and dry unless they secure legal authorization. This means that the commission of torture by the United States entails not just degrading acts to both the torturer and victim, but a second degradation, which is really the subject of my remarks, torturing the law, so that everyone can feel insulated from the risk of persecution or prosecution, even though they are all both high government official and low-level operative, in my view, knee-deep in blood. Now, in my extended text for the law review, I canvassed in many ways the infamous Bybee and John Yoo memos, torture beyond recognition, in my view, the international law of treaties, international criminal law, and so forth. And engaging in this critique, which others have done as well, is like shooting fish in a barrel. But I will be considerably more brief here because I suspect others will deal with this as well. But just to canvass this and sort of lay out my views on this, the Bybee Yoo memos torture the law of treaties by first ignoring many of them. That is, the International Covenant on Civil and Political Rights, the human rights obligations under the OAS Charter, and the Refugee Convention. Second, by contending that other treaties, such as the 1949 Geneva Conventions, are inapplicable. And third, by torturing beyond recognition the meaning of other treaties, including the Convention Against Torture and Cruel and Inhuman Treatment, which becomes, in effect, in these memos, the convention for certain forms of torture and cruel and inhuman treatment. The memos turn the numerous treaty prohibitions on torture into a rule that, unless our president says otherwise, prohibits only those forms of physical abuse that basically produce stressful pain tantamount to death, as well as perhaps including psychological mental abuse, but only if it provokes permanent damage that is demonstrable. The memos read treaty injunctions against cruel and inhuman treatment to limit U.S. action only within U.S. territory and perhaps with respect to U.S. nationals abroad, but only as those limits are specifically recognized by the U.S.'s War Crimes Act. Now, by focusing only on the prospect of criminal prosecutions under U.S. law, 50 to 100-page memos that purport to canvass all the legal, historical, policy, and operational considerations relevant to detainee detentions, and I'm now quoting the title of at least two of the memos. Despite that promise, they managed to ignore 14 articles, 14 provisions of the Torture Convention, innumerable international authorities on the interpretation of those articles and the meaning of torture itself, the rules limiting the scope of acceptable treaty reservations, and the rules for state liability for breach of treaty. But the treatment of treaty obligations, what I call the torture of the law of treaties, in these memos is sterling by comparison to their treatment of customary international law in Jus Cogens. These sources of international obligation are relegated to the status of non-law, not just non-federal law, but not law at all in these memos. The memos dismiss the Universal Declaration of Human Rights, other sources of custom in Jus Cogens, as policy instruments that at best may, quote, inform the views of other nations, close quote. The memo writers tell us that in any case, the President's proclamation that we are at war against enemy combatants trumps any customary rules that other countries, apparently foolishly, believe are legally binding. International criminal law is rendered unrecognizable in memos that unbelievably fail to address crucial questions like what constitutes aiding or abetting or conspiracy in the international crime at stake here, but still manage to create fictional defenses of self-defense and necessity, defenses that, if accepted, would render the whole category of war crimes an empty set. Nuremberg law that superior orders is not a defense is transformed through the magic of reinterpretation into a defense along the following lines of the President made me do it. Nor does the U.S. Constitution escape mangling. The memos favor cramped views of the 5th, 8th, and 14th Amendments. The U.S. constitutional ban on cruel and unusual punishment is confined only to post-conviction interrogations, despite dicta to the contrary in numerous cases. Due process guarantees are stated not to apply to non-resident enemy aliens or unlawful combatants, and even when they are under U.S. control in Guantanamo. And constitutional checks and balances on separation of, and separation of powers principles are all bypassed through an expansive and lawless reinterpretation of the scope of presidential powers. But you would say all of this should draw just a never mind, because after all, the president has renounced all of this. You would see in the Comey memo. Hasn't, in fact, in the Comey memo that I notice is in your CLE materials, hasn't the administration said, in effect, that, look, these were all shoddy memos written by overzealous sycophants. We've changed our minds. Well, yes and no. That is, it would be gratifying to say that the Bush administration's more recent renunciations of torture that were adopted, incidentally, in the glare of the photos at Abu Ghraib, and a few days before Gonzales would face a grilling to become Attorney General, have made these critiques that I've just briefly surveyed irrelevant. But alas, the memo on the Comey memo, and I urge you to read it, is quite hedged. It's the memo of December 30th, 2004. And it rectifies only some of the foregoing tortured interpretations of the law. The Comey memo disavows the use of torture and says that torture does not only encompass exceptionally severe injury, such as organ failure or death. So far, so good. But the new memo does not disavow prior legal interpretations of the apparently unlimited powers of the Commander-in-Chief, stating only that it is unnecessary to consider this. Nor does the memo revisit the scope or meaning of the international and U.S. constitutional bans on cruel and unusual punishment. Indeed, Attorney General Gonzales continues to suggest that some forms of cruel, inhuman, and degrading treatment remain permissible during interrogation, at least for the CIA, when the U.S. agents act at least outside the territory of the United States. The administration is also currently opposing proposed legislation that would enumerate permissible interrogation methods or that would criminalize sending individuals to places where they might be tortured even when U.S. agents act abroad. The administration's belated assurances in the Comey memo that it does not itself engage in torture also leaves in place the last memorandum included in the torture papers. Then, Assistant Attorney General Jack L. Goldsmith's March 2004 memorandum to administration's top lawyers. This memo apparently continues to reflect existing administration policy. I asked that the Goldsmith memo be included in your papers, but I didn't see them there. But at some point, I hope you can get a copy of the Goldsmith memo. That memo has largely escaped criticism. Goldsmith avoids claims about the meaning of the U.S. Bill of Rights, the scope of presidential powers, or the availability of general excuses like necessity or self-defense. His memo does not address torture at all. It is narrowly focused on the meaning of just two words, deportation and transfer. In a single sentence, in Article 49 of the Fourth Geneva Convention, which prohibits individual or mass forcible transfers as well as deportation of protected persons from occupied territory to the territory of the occupying power or to that of any other country, occupied or not, regardless of their motive. Now, I urge you to read Goldsmith's memo. Goldsmith concludes, contrary to the unequivocal ban that I have just read, that this does not prevent the permanent deportation of illegal aliens from occupied territory, nor the temporary removal of all others, including Iraqi nationals, for purposes of facilitating interrogation. The memo's erudite 14 single-spaced pages seem plausible applications of plain meaning, object and purpose, and context. Unlike Bybee and John Yoo, Goldsmith seems respectful, not contemptuous, of both treaty and customary sources of obligation. Appearances can be deceiving. Upon closer inspection, this memo shares some of the flaws of the more notorious torture memos. Indeed, the memo is all the more dangerous, in my view, because the conclusions reached have such surface appeal. Now, the more plausible of Goldsmith's conclusions is that Article 49 does not preclude the normal application of an occupied territory's immigration laws, and therefore it does not stop us from deporting illegal aliens who, by definition, have no legal right to remain on occupied territory. Now, contrary to Goldsmith's efforts, nothing in the plain meaning or object and purpose of Geneva IV suggests that the categorical ban in Article 49 was meant to include a silent exception for aliens, whether legal or illegal. The term protected persons in Article 49, as elsewhere in Geneva IV, presumptively includes all civilians who, quote, inhabit occupied territory. The Convention makes clear in other articles when its drafters meant to exclude non-citizens and its various protections, and they did not do so in Article 49. Goldsmith's efforts to import a nationality distinction into the term deportation is convincing only if one ignores, as he acknowledges, the usual use of the term under American law and Black's Law Dictionary. And even if Goldsmith were correct about the meaning of deportation, he faces a problem in that Article 49's ban extends equally to forcible transfers and not merely deportations. Nor is it true to suggest, as Goldsmith does, that the Nazi policies that triggered Geneva IV extended only to the removal of citizens of occupied territory. Goldsmith is quite correct. The Nazis tore people from their homes and caused them to disappear into the night. But he is wrong to suggest that these horrific acts were limited to the citizens of the occupied territories, or that the drafters were only horrified to the extent such acts were directed at such persons. Nazi actions directed at people within occupied territories had been widely publicized at the time Geneva IV was negotiated. The Nazi fog and night campaigns and other forced labor practices had gathered international attention during the Nuremberg trials, including the subject of Michael's remarks at the beginning of the judgment at Nuremberg. It was well known that such horrors befell, quote, whole populations, including German aliens living in occupied territory, such as Anne Frank, living in the Netherlands. We cared about how it happened to the Frank family because they were forcibly taken from their home to concentration camps abroad, not because of their legal status in the Netherlands. At the time the negotiations for Geneva IV were going on, evidence was being heard in Germany, as you've heard, in the occupation trial known as the Justice Case, which ultimately convicted the Nazi Minister of Justice for, among other things, quote, creative reinterpretations of the then existing Geneva Conventions. That trial described the Nazi night and fog scheme to combat so-called resistance movements in occupied territories by enslaving, deporting, and imprisoning many thousands of the civilian inhabitants of those territories, especially Jews and Poles, and by making these people disappear, thereby terrorizing into submission those left behind. It was clear to everyone that the night and fog tactics applied to all resistors of occupation and all others who incurred the wrath of the Nazis, irrespective of the nationality or legal status, and indeed often based on racial discrimination that served to target the Jewish inhabitants of the occupied territories, whether or not they were citizens of such territories. It is simply ahistorical to suggest that the Nazi acts that were the focus of Article 49 targeted only legal aliens or citizens of occupied territories. The plain meaning, object, and purpose and context of Geneva IV do not support Goldsmith's attempts to read illegal aliens out of its protections. His second conclusion, that despite the categorical ban on transfers and deportations in Article 49, that anyone can be taken out of occupied territory for some unspecified time to be interrogated at the behest of the occupying power is, in my view, even more implausible. Again, Goldsmith reads this exception that is nowhere suggested by the plain terms of Article 49 into the words deportation and transfer. Again, he can get no help from the dictionary since, as he acknowledges, the plain meaning of transfer is to remove from one place to another, even for a temporary period of time. Again, he argues that the ban on forcible transfers should effectively be read out of Article 49, and his interpretation of transfer to mean only permanent or indefinite resettlement is belied by the terms of Article 49 itself, because its second paragraph, providing a guarantee that evacuated persons be, quote, transferred back to their homes as soon as hostilities in the area in question have ceased, expressly calls such temporary evacuations transfers and requires these to be as short as possible. The drafters of Article 49 obviously use the word transfer to mean what its plain meaning suggests, any removal, even for a temporary period. In this instance as well, Goldsmith attempts to draw support for his strained interpretation from the Nazi policies that were the target of Article 49. He suggests that these involved only the permanent resettlement of the inhabitants of occupied territory. But there was abundant evidence, widely known to the negotiators of Geneva IV, that the Nazi transfer policies, especially under the Night and Fog decrees, were not limited to permanent, extended, or at least indefinite resettlement. As was made crystal clear in the Justice Case, although the Nazis exterminated many of those they removed from occupied territory, vast numbers of persons were removed in secret from those territories and subjected to, quote, brutal third-degree methods of interrogation, close quote, but were detained abroad only for a short period of time. The central concern of the judges of Nuremberg and of those who drafted Article 49 was not the length of time a transferred person was kept outside of occupied territory, but the discriminatory policies that led to their being selected for transfer, the secrecy of the process of removal, and what they called the cruel, quote, terrorist impact on those left behind, the inhuman treatment suffered by those who were removed, including during periods of detention and interrogation, as well as, of course, that for some, but not all, secret removal, even for a short period, meant death. The Nuremberg trials associated the secret transport of the inhabitants of these occupied territories with the, quote, torture of civilians by the occupying forces, close quote, precisely because this is what the Nazis did. We convicted Nazi officials, including their high-level lawyers, under Control Council Law Number 10, which barred deportation of the civilian population for slave labor or, quote, any other purpose, close quote, precisely because the removal of inhabitants from occupied territories for the purpose of, quote, efficient and enduring intimidation, close quote, constituted a violation of the laws of war. For anyone grounded in the history with which this treaty, Geneva IV, was intended to deal, and its object and purpose, it is absurd to contend that the drafters of Article 49 would have approved of a free-floating exception for short-term transfers abroad that could only be of benefit to the occupying power, and with no guarantees to prevent that abuse of that power. For all of these reasons, the Goldsmith Memo also tortures the law of treaties, albeit with more subtlety than with some of the other torture memos. Now, let me put this memo in a broader context. The date of the Goldsmith Memo is March 19th, 2004. He drafts this opinion in the wake of the Red Cross's February 2004 report that documented many apparent violations of Geneva law during the arrest, internment, and interrogation of detainees in occupied Iraq. He writes this memo amid growing news reports of abuses and even deaths while under U.S. detention in Iraq and elsewhere. His memo is contemporaneous with the first investigative report by the U.S. government itself of detainee abuses in Iraq, the Tagoba report. It precedes by a month the public revelation of the infamous photos at Abu Ghraib and the leaking of many of the infamous torture memos by Bybee and Yu. But by the time Goldsmith is asked his opinion, it is too late for the administration to back away from its public position, by then affirmed by the UN Security Council, that Geneva law extends to Iraq. Unlike Bybee and Yu, Goldsmith does not have the option of simply declaring Geneva law inapplicable to Iraqi detainees because this is some kind of new occupation involving terrorists. Goldsmith is asked to express his opinion about whether it is legal for the U.S. to remove any and all individuals from inside Iraq when the possibility of continuing maltreatment of Iraqi detainees inside Iraq is becoming untenable as a legal and a public relations matter. Now, there may indeed be legitimate reasons for interrogating some persons outside of Iraq. But the most obvious reason to want to do so is precisely to avoid the scrutiny that interrogations inside Iraq tend to produce, or to use non-U.S. personnel to engage in the most coercive forms of interrogation. The Goldsmith opinion is, according to its precise terms, limited to the rare case where the U.S. government is an occupying power, that is, Iraq. But yet, a legal opinion that concludes that our government can seize anyone that it wishes from territory over which it exercises de facto control, and can transfer such individuals to places unknown for unspecified periods of time for purposes of interrogation with no questions asked, encourages such transfers generally and has much broader implications. At a minimum, it gives U.S. interrogators an additional and, in my view, illegal tool, the threat to send any detainee abroad to places where he might be tortured by others. Both before and certainly after Goldsmith writes his memorandum, there were growing and widely available reports in the press and by human rights groups that the United States appeared to be outsourcing torture and other forms of coercive interrogation by sending those it suspected of being involved in terrorism to countries that the State Department itself had identified as regular practitioners of torture, including Egypt, Jordan, Morocco, Saudi Arabia, Yemen, and Syria. Indeed, 5 days after Goldsmith writes his memo, Newsweek reported that the United States was allegedly running a covert charter airline to move CIA prisoners from one secret facility to another. While the United States has never confirmed the accuracy of these reports, at the time that Goldsmith was asked for his opinion, there were numerous public statements by various U.S. government officials that are consistent with a policy of relying on others to undertake forms of interrogation that the U.S. government had by then been required to forswear inside Iraq in the glare of Abu Ghraib. If, as seems clear, the Goldsmith memo continues to reflect existing U.S. policy, the administration's more recent renunciations of torture are hollow. They amount to a statement that U.S. government officials will not themselves engage in certain interrogation techniques, at least inside U.S. territory, but will not seek to prevent others to whom it transfers people from doing so, and in fact may be engaged in such transfers hoping or anticipating just such an outcome. If, even in the context of Iraq, a country that at least at the time the Goldsmith memo was written was unquestionably subject to Geneva law and today remains the focus of intense media and UN scrutiny, we insist on our right to transfer any and all individuals to facilitate interrogation to other countries. Is it realistic to expect that we are not engaged in outsourcing torture elsewhere, where we face not the reciprocal rules of Geneva law, but only the constraints of human rights instruments that the administration's own memos say do not have the force of law at all? The Goldsmith memo adheres to the pattern of the rest of the torture papers. Like the more notorious memos in that collection, it denies the equal application of the law and has a deaf ear for legal conclusions that encourage national, ethnic, or religious discrimination. It too adheres to a depressingly familiar formula. First, find a location that is relatively impervious to judicial scrutiny. Second, deflect, rescind, or avoid Geneva law. Third, provide a legal interpretation that protects U.S. personnel from criminal prosecution, if only by rendering what was formerly a relatively precise war crime into one that is now ambiguous in its scope and therefore subject to the rule of lenity. And like the Bybee U memos, it is part of what I would consider to be a conspiracy for torture. Now, if the Bybee U memos constitute a roadmap that inevitably led to abuses within U.S. custody, the Goldsmith memo is a roadmap to the outsourcing of torture and other forms of abuse. Of course, numerous treaty obligations of the United States, apart from Article 49 of Geneva IV, prohibit the refoulement of an individual to another state where that person faces the danger or risk of torture. The other treaties on point include the ICCPR, that's the International Covenant on Civil and Political Rights, the Torture Convention, and the Refugee Convention. That obligation also exists under customary law, and some of these treaties also say that such extraordinary renditions have to be criminalized. As the Goldsmith memo acknowledges, but only in a brief footnote, violation of Article 49 of Geneva IV constitutes a grave breach and is therefore a war crime. In addition, U.S. law makes it a federal crime to commit, attempt to commit, or conspire to commit an act of torture outside the United States. The Goldsmith memo barely says a word about any of these obligations. I leave it to others to consider whether U.S. officials are less morally culpable when their role is limited to making persons available that others will torture. But even assuming that that were true, the subcontracting of torture to non-U.S. officials has its own nefarious effects. Given the United States leadership position with respect to showing the world what measures can be legally taken in the war on terrorism, when U.S. officials acquiesce in or enable such activity, or use information obtained by such methods, it is suggesting that such methods are acceptable. The United States subcontracting of torture undermines the ban on torture and inhuman treatment no less than if it were engaging in these practices itself. It is difficult to maintain that these prohibitions are erga omnes obligations that all have to follow. If others know, and of course through subcontracting they must know, that all we are saying is that we don't do them. In any case, international criminal principles of complicity, conspiracy, aiding and abetting anticipate criminal liability, including command responsibility, for knowing acquiescence in illegal activity by others, even if the principal perpetrator is unidentified or if their guilt cannot be proven, and even if the accomplice did not wish that the principal offense be committed. There's one other aspect of the Goldsmith memos that I want to focus on, and that's the rules of professional responsibility. The Goldsmith memo shares this other feature with the torture memos. It reflects a mode of lawyering that I think students ought to pay close attention to, because they may get in trouble with it too. It too reflects a result-oriented approach in which the government lawyer, in this case, whose advice is sought, starts with an objective that the lawyer believes the client wants and works backward to achieve it, even at the expense of the law itself. The Goldsmith memo, like most of the other torture memos, consists of lawyers' advice with respect to actions that clients are then contemplating and in some cases have begun to take. The memo, like the others, is not drafted for purposes of public consumption. But this is not an exculpatory fact. On the contrary, the fact that they were written in confidence by lawyers to their clients is all the more reason to expect that these memos would provide the candid, independent, and professional, not sycophantic advice that the rules of professional responsibility demand. The memos should have candidly warned the relevant government officials not only about the risk of criminal prosecutions under U.S. law, but the risk of civil liability for the United States government under established rules of state responsibility. Goldsmith tortured the rules of professional conduct insofar as he did not enable his client to make an intelligent and informed decision on the basis of real and not fanciful law. The Goldsmith memo focuses like a laser beam on the narrow parsing of two words, ignoring all other legal, moral, economic, or social considerations. But the rules of professional responsibility urge lawyers to consider the moral, economic, social, and political factors that may be relevant to the client's situation. Now, we don't know whether in subsequent drafts or in other memos that have not been made public, Goldsmith or other government lawyers provided that needed context. But the March 19, 2004 memo does not remind the client that should the United States transfer illegal aliens or others from Iraq, it would need to, in any case, consistent with Geneva law, inform the International Red Cross of such transfers. Given the contemporaneous allegations of U.S. government-sponsored disappearances or phantom or ghost detainees, one would have thought that a lawyer providing a potential roadmap for such acts would have reminded the client that transfers from Iraq, should they take place, cannot be in secret or in the dead of night like those of the Nazis. One would have thought that a memo written in March 2004 would have warned the Attorney General of the potential for more embarrassing Red Cross revelations should removals be undertaken without real assurances that U.S. personnel once outside of Iraq or foreign officials, where the transferees were ultimately found, would not maltreat them. One would have thought that a memo about a treaty provision directed at preventing night and fog tactics would have been accurate about describing what those tactics were, and would have warned those tempted by them that facilitating interrogation without mechanisms for controlling the abuse of power by the occupying power have historically led to extrajudicial torture and killing. One would have thought that a memo whose first conclusion is premised on the principle that we need to respect existing Iraqi immigration law would consider whether that law really existed or was operable in Iraq in March 2004. Goldsmith instead shows a total lack of curiosity with respect to the fate of those who are suspected of being illegal aliens in either pre- or post-occupation Iraq, or those who are rounded up for interrogation by its occupier. If, as one suspects, at least at the time this memo was written, Iraqi immigration procedures were in substantial disarray, there is grave doubt about whether the transfer of illegal aliens or the determination of whether they were legal or not would comport with any law whatsoever. The same can be said with respect to the procedures that are never addressed in this memo for those who are forcibly removed from Iraq for purposes of interrogation. It's possible that the premise of the memo is an extraordinary one. That is, that it's not a violation of Geneva law, international humanitarian law, or international human rights law to forcefully transfer anyone even if local law cannot be given effect, and therefore such persons get no due process whatsoever before they are disappeared. Let me conclude, and I'm very close. The UN Charter's human rights provisions, the Geneva Conventions, the Nuremberg Trials, the Torture Convention, and other foundational instruments of International Bill of Rights, such as the Universal Declaration of Human Rights, and the two human rights covenants have, I think, at least the students in this room, recognized a special status. They are regarded as the constituent instruments of modern international law for good reason. They marked a transition from using public international law to address only interstate problems to using this law to protect the dignity and life of the individual, regardless of whether the individual is a legal or illegal alien, a lawful or unlawful combatant, or a mere inhabitant of occupied territory. Nuremberg made clear, in addition, that these obligations were so essential that violations of certain of them would be criminalized. That is, that individuals, no matter their status, would henceforth be held criminally accountable, that certain international crimes were universally abhorred, and that it would not be a defense from criminal liability to point to national law of any kind, whether or not this law purported to have constitutional status, to address only the executive branch, or to govern only its military. These developments, which we helped to forge in the horrors of World War, legitimized the use of international legal discourse to address issues that all too often had been banished from legal discourse altogether. The torture papers are a massive retrograde step, wherein these sources of international obligation that are not ignored or relegated to mere considerations of policy are mangled beyond recognition. The memo writers torture the foundational elements of modern international law. They attempt to return us to a time when international law protected only the perceived needs of certain states as determined by those states themselves. To the extent the memos excuse torture or inhuman treatment, when this occurs outside U.S. territory or is committed by foreigners with U.S. acquiescence, it returns us to a dark period when colonial powers renounced torture for their own citizens while deploying it on those whom they called, with no sense of irony, the uncivilized. Now, I understand well the conditions under which these memos were produced. As Michael referred to, I was once a government lawyer. And in my time in the State Department, there were considerable pressures to produce similar can-do memos. I can also understand the frustration of those who produce these memos under such pressures, only to have their conclusions that were never intended to be on the front page of the New York Times scrutinized by law professors with the luxury of time and research assistance. Yet, the notorious history of the Nazi lawyers who, in the words of Michael Scharf's introduction here, in the words of the Justice case, quote, prostituted a judicial system for the accomplishment of criminal ends, close quote, those words hang over all of us. Once these memos became public, it became the duty of all of us, government lawyer, private citizen, law professor alike, not to let their authors off the hook, to look at the conclusions reached, and to consider what our government is alleged to have done and is perhaps continuing to do in their wake. And if we do not, we risk becoming complicit in the abuse of human beings as well as the abuse of law. Thank you.
All right, well, Jose did the unthinkable, or unimaginable. He had a 52-page paper that he was able to boil down and still finish with 5 minutes left. Why don't we take...
I speak fast.
Why don't we take a question or two and then end directly at 9:30, and then we'll take a 5-minute bathroom break because it is a human right, and we'll begin our next panel at 25 up. So you can just go and point to people. We do have... where are our students with the little handheld microphones? Are you around? Oh, okay, you'll have to repeat the questions if you
Sure,
find the students. They'll be here later. Okay, go ahead.
Okay, ready?
Do we have any questions?
Silence them all. Michael, you must have a question.
How about you panelists?
Sharif?
There you go.
About the book, isn't
I didn't find it. I didn't in the CLE materials.
Yeah, it should
Oh, wait, is it the Comey memo or the Goldsmith memo? Oh, good. If it's there, because I did send it in. If you pick up the Goldsmith memo is readily available. If you pick up the book that I described called The Torture Papers, it's roughly around page 540. And then right after that starts the Taguba report, the Red Cross reports, a variety of other reports. But it's the last of the administration memos included in the Torture Papers.
Has there been any retaliation against Goldsmith?
No. That is, most of the torture writers have either returned to their academic positions or increased in prestige. Mr. Goldsmith is now teaching at Harvard. He was formerly at Chicago and Virginia. Mr. Yu is now teaching at Berkeley and is on the torture circuit doing these kinds of talks. That's why I find these things unappealing. And Bybee is a federal judge. Ninth Circuit?
Okay, are they traveling to Belgium? You mentioned.
No, yes. Apparently, the legal advisor's office is somewhat concerned about former officials of this administration getting into trouble for these memos. I wonder why. But Belgium is a particular concern. Spain may be a particular concern. And it's not that they actually may face the prospect of a serious criminal prosecution, but it's nothing like, traveling to, say, Paris, Disney World, and having papers served in front of your family to sort of make things a little less fun. And what it's nice about that is that it's interesting that they're worried. I like that. Sharif.
I wondered whether if you look at the sum total of these memos as well as the President's executive order concerning enemy combatant, that we have not duplicated, in a sense, the George W. Bush Führer principle that we once saw in Germany. You sort of stop short of reaching a conclusion which, in my mind, would have been...
Michael referred to why. That is, I'm not, I'm not a prosecutor, right? And I'm certainly not an expert as to what was in their minds when this was written. I do disagree with some conclusions in the scholarship suggesting that these conclusions were rendered in the fog of war. That is, because we're so confused about which regime, apologies, Diane, are applicable. I think there was abundant internal advice given by JAG lawyers, by William Taft, I understand, by Colin Powell, among others, suggesting that many of these conclusions were extremely tenuous and controversial, and that at least the memos should have been more balanced in presenting the risks of taking this, and not simply dismissing the contrary as the views of other countries without getting into why they might think that. That is, what I find irresponsible of the memos, it's not just their conclusions, but the way they are drafted so that they ignore, and in the law review comments, I really go in depth as to what is not in the memo that you would want to be in a 50, 100-page memo. If you are truly canvassing for the purposes of a client all the relevant considerations, I think they shortchange the Attorney General and all the others who were receiving these memos.
Would your conclusion go one step further if you examined the process with which you are familiar of having all of these memos go to the NSC and then summarized for discussion by the NSC advisor to the President, Vice President, and the principals?
Well, I'm suspicious of process as being the solution here, because I think there was abundant process. That is, a lot of the memos were circulated widely before they got to the president's desk or the desk of the attorney general. So I'm not sure process is the key here. It's hard to pinpoint one factor here. We are told, for example, if you believe bloggers, that Jack Goldsmith actually stood up to the buy BNU line and said, not on my watch, when he came to the Office of Legal Counsel. And he was instrumental, I understand, I have no way of knowing, in saying that the most extreme aspects of those memos were simply unacceptable under existing law, and I applaud him for that. My suspicion is that since he closed the door, he was under pressure to open a window, and he did. That's what happens.
Well, we're out of time. If you have other questions for Jose Alvarez, there will be a quick 5-minute break, and we'll start promptly at 25 up. Please join me in thanking Jose.
Hey, the bathroom door. Yes, sir. You come through these doors, and there's going to be a little hallway straight ahead. Yeah, it's right on the right. All right.
We've talked, but this is our first one.